one is there enjoying it. Probably.
Oh,
But you'd have to go back to you'd have to go to YouTube and where it was streamed. And that's what but while it's up, you can see them in real time.
can we see him later?
Yeah, yeah. We're up and good.
All right, we are back on the record. Jurors, please, unless there's some preliminary matters.
Not half the people.
Not at this time, Your Honor, from the defense. Thank you.
Thank you. Thanks, that's for you. Yeah, that's for you.
Appreciate
All rise.
Thank you. You may be seated, sir. I'll just remind you, you're still under oath, and counsel, you may proceed.
Thank you, Your Honor. So your testimony has been that you do not remember what you told Detective Bramman in November of 2024 because you were high that day, correct?
Yes,
Were you high on Tuesday?
I don't know.
You don't know if you were high on Tuesday?
Oh, you're, no.
Okay, so your first day of testimony, you weren't high then, right?
On Tuesday.
You were not high that day, correct?
Yes.
Okay. Now, your direct examination from today, you made a point to specify that it was Eaton Rap Drogs' our house. It was our house, calling it our house, our place. Is that right?
Yes.
Is that because you realized after your testimony on Tuesday that for that entire day, you referred to that location as her house, her place?
No, it never even crossed my mind.
No. Do you remember referring to it the entirety of your first day of testimony as her house and her place?
Yes, I do.
Okay. Is it true that you, throughout your entire hour-and-a-half interview with Detective Bramman, when asked extensively about where you have lived over the years, never once said that you resided at Eaton Rapids Road?
I don't know what I told her.
Don't know. Safe to say you're having a difficult time remembering a lot of things, right?
No.
No, you're saying that you're having a good time with your memory?
Yes.
How many times do you think you've responded with, I don't remember, I don't recall, today alone?
I don't know.
No, can't remember, right? All right, let's see what you do remember. People's 9. From May 6, 2020, do you remember texting Alyssa, I'm be getting all my shit through that window I unlocked too? Do you remember texting her that?
No, I do not.
Do you remember texting her, bitch, you're through? On God, you want to play? I'm gonna fuck your life up.
No, I do not.
Okay. Let's move to People's 10, May 18th, 2020. You don't remember texting her and beating your ass, right?
No.
Do you remember texting her, don't make me kick that motherfucker in?
No, I do not.
Do you remember texting her, bitch, I'm kicking the door in. I put that on my kids and everyone dead. I'm done talking. I'm around the corner. Do you remember texting her that?
No, I do not.
Do you remember texting her, you better not have my baby out and Mercy better be on the way or I'm fucking kill you. I put that on the Bible, bitch. Don't play with your life.
No, I do not.
No. Do you remember at any point in your relationship threatening to murder her and saying, I put that on the Bible?
No.
No. Equals 11. Do you remember texting her May 25th, 2020? I'm smacking the fuck out of you, bitch.
No.
How about I'm gonna kick this bitch in and break everything?
No.
In your testimony is nothing happened on May 25th, 2020. There, in your words, there was no incident, right?
I don't know.
You don't know?
I don't know.
So on direct examination, when you said, in response to your own counsel's questions, was this from May 25th, 2020? You said there was no incident that day. Do you remember saying that before the lunch break?
Yes.
Okay, was that true? Did no incident happen on May 25th, 2020?
Yes.
So then why did you just say you don't know if any incident happened on May 25th of 2020?
I wasn't listening to the dates. I'm sorry.
How frequently throughout this trial have you not been listening to the questions that have been asked of you?
That's the only time.
Only time, got it. May 25th, 2020. Do you remember receiving a text from Alyssa Clark? The police came earlier and seen me through the window. They said somebody called and they said they seen me run from this house bleeding. Do you remember receiving that text?
No.
No. Listen to People's 12. Now you testified on direct. You do remember these text messages. Isn't that right?
Yes.
Got it. So you remember texting Alyssa, after I beat your ass, you begged me to stay, bitch. Right?
No, I don't remember those dates.
Okay, so now your memory has changed since before lunch.
No, it hasn't.
Are you high now?
No.
Okay. Do you remember texting Alyssa, you see what I said, this for life, only way out is death? Do you remember texting that?
Yes.
Yes. So you have told her the only way out is death, right?
Yes.
But that's not a threat, right?
I never said that.
Didn't you say in response to questions from your own counsel, yes, you had said, I'm gonna kill you, but it wasn't threatening?
I didn't act upon the threat, is what I said.
That's not my question.
No.
Is that a threat?
No.
No. This isn't a threat. Your testimony is, this is not a threat that if she were to try and leave you, she would be killed.
No.
Great. This is from that same exhibit that you said to your counsel, you remembered these messages. Do you remember? Alyssa texting you, when I pop up dead, I hope that shit haunt you for life. Because at this point, I'm gonna do what I gotta do to get out. I can't take it anymore. And you reply with, shut the fuck up. I said I ain't going nowhere. You know this. I said I love you. Do you remember these text messages?
No, I haven't seen these ones.
You did not see these text messages
Not that-
on Monday?
No.
You definitely were high on Monday, right?
Right.
So you did not see these put on the big screen, on the screen right by where you were sitting, and me read them aloud, line by line. You don't remember that.
No, I was taking notes.
So you don't remember from Alyssa's testimony in this trial. Is that what you're saying?
I don't remember that page you just showed us one time.
Oh, of course not. How about this one? Do you remember? I said you mine for life. And you know this, I don't care what the fuck you think this is, you know it's death to get out, so take it how you want. Do you remember sending that text to her?
No,
And I guess I now have to start asking, do you remember this text being admitted and read on Monday?
no.
No. Tell you what, Your Honor, if I could approach what's people's 12?
Sure.
Since you don't remember this ever being admitted or read, you go ahead, look through each one of those pages and read them to yourself. Since this will apparently be the first time you ever see it. And you let us know when you're done. Oh, don't go quickly, sir. Lead. Sir, you're done in 20 seconds reading a 14-page document?
No, I recognize the fronts. I just didn't see those exact pages. I was like.
Great. Read them.
Oh, wait a minute. Let's not waste time. We don't need to. Sir, do you remember writing those?
Yes, I remember those.
Okay. And you remember there was a lot of testimony?
Yes,
And there was a lot of testimony about the emails, and they were actually put on the evidence screens, correct?
yes.
Okay, so are there any you need to review before you answer the questions?
No, I just seen them up there.
Okay, so if you don't remember and counsel's asking you a question, they're right there, flip through them before you answer, is that fair?
Yes.
We'll save some time that way, counsel, if you don't mind.
I need to have them back for
You
this.
can have them back and then
Thank
you
you.
can have you hand him whatever it is if he doesn't remember, thank you.
Thank you.
How about this page? Do you remember texting her, go back home, or I'm pulling up and telling her, I said it ain't over till you're dead. You know I'm dead ass serious. Didn't I say go home? Do you remember texting her that in September 16th of 2020?
No, I do not.
Do you remember texting her? Bitch, I own you. You're my property.
No.
Do you remember ever saying to Alyssa, bitch, I own you. You're my property?
No,
No. Did you ever put a GPS tracker on Alyssa's car?
no.
Did you tell her you would put a GPS tracker on Alyssa's car?
Yes, I did.
Why did you lie to her about putting a GPS tracker on her car?
Because she did something that she had my location on my phone, so I just lied to her, said I had her location.
And what was the point of that?
Just basically, like, you know, what I'm doing, where I'm at, I know what you're doing, where you're at also.
And why was it important to you that she knows you know where she is at all times?
Because she knew exactly where I was.
She knows what?
She knew exactly where I was.
It wasn't to make her afraid that you could come find her at any point, right?
I mean, no, that was, no,
No.
no.
It wasn't so you can send texts like, you broke ass ain't out there, your car won't even make it, bitch. I see where you're at right now, fucking clown ass bitch. Now I'm really coming to beat your ass. It wasn't so you could make her afraid with that, right?
No,
No. Do you remember texting her, come out before I take this battery and jump through this window?
no,
No. Because you definitely didn't take her car battery, right?
correct.
Correct. Were you lying to her then too? Threatening to take a battery like you were lying about the GPS tracker?
Those aren't my texts.
Those aren't your texts. Of course not. You're saying these are fabricated, right? Mr. Brooks?
Yes.
Got it. Did you text her? Bitch, I'm by your car. What don't you get? I got GPS. Come the fuck out or I'm breaking this bitch. Bitch, this is my last time telling you on my kids. You text her that?
No.
Would you frequently swear on the lives of your children that you were going to assault Alyssa Clark?
No.
No. People's 13. Did she text you November 1st, 2020? You could have left me brain dead today, and you reply with, baby, I know, I'm so sorry. Did you text her that?
No.
So this of you admitting to nearly killing her November 1st, 2020, that's all fabricated, right?
Yes, that's not from my phone.
And you never sent or received these, right?
Correct.
Now, in 2023, you were charged with the harassment about the posting of the messages. Is that right?
Yes.
Isn't it true that while there's no contact order in place in 2024, you texted Alyssa this very long string of texts about tell my babies I said happy birthday and I love them?
No, I did not. That's not my number.
No. Isn't it true that you, when she kept blocking you, would use text now numbers in order to be able to contact her?
I have one text now number. No, not to contact her.
You did not use text now numbers to contact her.
We talked on it, but I didn't make it to contact her.
Have you
No.
contacted her over text now?
Yes.
What is your text now number?
Text now number was 517. I don't know.
Wait, let me just stop. What is a text now number? Is that different than how we text on our phones?
Yes, ma'am.
What is it?
You can download the app to get a new number.
Okay, so you use it on your phone, but it's not your number. You download a separate number, and that's called text now.
Yes.
Can you download as many numbers as you want?
I'm not sure.
Okay. And you had a text now number?
Yes, I did.
Okay, thank you. Thank you.
So you don't know what your text now number was, but you know for a fact it wasn't this one, right?
Yeah, I didn't have 616.
No, of course not. Yours was 517 and nothing else, right?
Yeah, it started with 4, but I don't remember the exact number. No.
Start with a 5 or a 4?
4.
A 4.
Yes.
The area code or the phone number?
The phone number.
One moment, Your Honor. Gonna show people 16. Now you've already said these texts are real, right? These are from September 2023 in regards to the posting.
No.
No, so now it's not real anymore. It was real when Mr. Freeman was asking you about it for about, I don't know, 45 minutes. But now that I'm asking the question, this isn't real, right?
Can you pull it down a little bit? Yeah, I don't know.
So now you don't know if this is real. How about this? This here. You sent her the social media metrics from your posts, right?
Okay, yeah, I remember now, yep,
Okay, so these were you.
yes.
Hey, that's a text now number, right?
No, it would be purple. It would pop up green like an Android on an iPhone.
Are you saying that that number is your cell phone?
No, it was a friend of mine.
So you used a friend's phone to contact her.
Yes,
Did you do it with the other one too?
no.
No, definitely not then. Right.
Definitely not.
Definitely not when there was a court order in place saying you're not allowed to talk to her, right?
Definitely not.
Like you said, that you wouldn't do that. A court order would stop you. You definitely wouldn't violate it, right? Right. You sent her the video of her giving you a blowjob, right?
Yes,
This is you.
yes.
You want to play bitch, it's up. Now you got me started. What do you mean by it's up?
It's just a firm basically saying like,
You mean it's uploaded, right?
no, it's up like, basically, I'm gonna be on some bull ass like you are on. That's what I'm.
Really? So was it in reference to you all over the Reddit, bitch?
No,
No. Hey, what's Reddit?
Reddit is, it's another app to download.
Describe it.
They got social media posts on there, breaking news.
You can post things anonymously on Reddit, correct?
I'm not sure, I never posted on Reddit.
Really?
Yes,
So this here of you saying you all over the Reddit, bitch.
yes, that was a lie. This was an attempt to get her to take that video down as well.
So everything that's incriminating, those were lies you said, right?
As far as what?
The GPS, beating her, posting her naked photos on Reddit. Everything that you admit you've done, if it's incriminating you, it's a lie, right? Then you're lying, right?
I've never did that, no.
No. So if it's incriminating, it's a lie, right?
No, I've already admitted to things, understand. That is incriminating myself,
Really?
yes.
Sir, when you talk about, yes, I was accused of domestic violence before, I was arrested of domestic violence before, well, then it was, no, those were false reports, right?
Yes, I was arrested.
And they were false reports, right?
Yes, I wasn't sentenced, charged with anything.
The claims were false. First of all, are you saying you weren't charged with anything?
Yes,
There were criminal cases where you had to appear in court because you were charged with crimes against the women you've had children with? Is that your testimony?
I mean, like, I didn't get in trouble for none of this, what I'm saying. I was charged with it, but they got dismissed.
Right. You threatened them not to come to court, right?
No,
So they were dismissed when they didn't appear, correct?
yes,
Right. So those were false reports. But then you said, oh no, I have put my hands on Alyssa before. You said that, right?
yes.
And each of those times, well, I wanted her to leave, she wouldn't leave, so I pushed her out of the house, right?
Yes,
Such immense admissions you're making there, sir. My God. You're trying to say, well, I've definitely done these things, which means I'm honest when I'm saying here, I didn't commit these charges, right?
false,
That's the only reason you're willing to say you put your hands on Alyssa in any way, shape, or form, correct?
false.
False. You testified on direct examination. You magically found a box of fraud in the apartment you got, right?
Yes,
My God. And then you didn't do anything with it. You didn't post any of it online, right?
I said I was looking into it, yes.
No, you testified that you did not post anything that you found in that box online. That's what you testified to this morning. Is that still the truth?
No identities I testified to, yes.
I'm sorry, say that again?
No identities I testified and said I didn't, sell. I was asked if I sold identities online, no.
You were absolutely asked if you posted anything online, but since you disagree, I'll ask it now. Did you post anything from that box online?
The video you guys seen, but not individual IDs or social, so no.
It was 55. The Telegram list. That's you posting that, right?
That wasn't in the box, but yes, that's me.
Okay, so you definitely didn't post from the fraud box. You just posted other people's credit cards, right? Yes or no? Yes or no, sir?
I said correct.
Did you put Alyssa Clark's ID and social security card in the fraud box?
Yes, I did.
Yes, you did. But you definitely weren't trying to commit fraud when you posted on Facebook, got a good ID to sell for $100.
No, definitely not, absolutely.
Definitely not, because no one hit you up in your inbox, right? That was your answer earlier this morning.
That and I wasn't gonna sell it.
Right. Definitely.
Correct.
Of course.
Definitely.
If I could switch to the HDMI, please.
All right, Chief.
It's good on, there we go. So People's 56.
Hey, guys, niggas be doing the same shit, bro. Same niggas got the evidence. You know what I'm saying? Niggas just ain't got no good food right now, man. That's all it is. Niggas do this shit, bro. That's what I'm trying to tell you.
Why'd you post that?
I didn't post it, that was sent to somebody.
Why'd you put it into a Telegram chat?
It wasn't a chat, it was just between me and one other person.
Hey, is a chat a conversation between people?
I don't know.
Why'd you send it to someone on the Telegram?
I don't know.
You don't know. Would looking at a copy of the Telegram log help refresh your memory about why you did this?
No.
No, of course it couldn't. It's not because you don't want to actually answer, right?
I already said, I said I was looking into fraud and stuff. I don't know what you want.
I would like to know why you posted the box of fraud of other people's social security cards, driver's licenses, and credit cards to a Telegram account where you were talking about committing identity theft. Why did you post this?
I don't know.
And looking at the log between you and the other person wouldn't help you understand why, right?
No.
No. Fair question then. Why did you decide to have your username on these Telegram chats be Scam Man?
Something I seen on Reddit.
Something you've seen on Reddit.
Yes.
Why'd you pick it?
Cause I looked on Reddit about scamming and they were saying, if you're gonna make a Telegram, don't ever use your real name.
Right.
Yes.
You testified to your attorney, the reason that you came back to the Eaton Rapids Road address was to get your clothes, correct?
Yes.
And you came back a second time after going to a store and, you know, it's COVID, and that's why you're wearing a mask, right?
Yes, I came right back.
Okay. Were there a lot of other people here in this video?
I'm not sure, you have to play it.
Hey, you got it. Let's play it.
No, I don't see anybody.
How about here, People's 54? You came back, right? Wearing a mask? Is that correct?
Yes.
Do you see a lot of people here?
So is it playing or is it a picture?
It's playing.
No, I don't see anybody.
Right, I get why you're confused because there's no one in these frames. That's you, right?
Yes.
That's you knocking the camera over, right?
Yes, that's what I testified to.
Right. I'm so glad you brought that up. You testified with your attorney that you came back, knocked on the door again, and when Alyssa didn't respond, you knocked over the camera. That was your testimony this morning, correct?
Yes, because we used the back, I was using the back door because I parked at this side of the parking lot.
Mhm.
So when I came around, I already had knocked on the back door.
Hey, do you knock on this door?
No, this is the front door.
No. And you want us to believe that you're being honest before, that you weren't trying to break in at that point. You were just, you're just trying to see if she would let you come in, right?
No, I just wanted.
Yes or no, sir?
No, sir.
Because you wouldn't try and break in through the window or anything, right?
Correct.
Right. Because all those texts from before, you saying that those were lies, right?
Yes.
Just like this was caused by a baseball bat, right?
Yes.
And I noticed you said today, you know for a fact, for a certainty, this was caused by the baseball bat from the other woman at that tussle at Max Bar, right?
We left together and she had that.
Yes or no? You testified today that you know with a certainty that's what caused that, right?
Yes.
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 Hey, on Tuesday, didn't you say you couldn't actually say if that was it because you didn't see it happen? You just assumed it did?
She told me it happened.
Sir, yes or no? Was your testimony on Tuesday that you didn't know if that's what caused it because you didn't see it? You just assumed that's what it did. Yes or no? Was that your testimony?
Yes.
Okay, what changed between Tuesday and today?
Nothing.
Nothing. So why'd your testimony change?
I mean, I believe her. I have no reason to not believe her.
So you have no reason for why. On Tuesday, you said you didn't know if this is what caused it, you didn't see it. But today, after having a day off, you know with a certainty you're not responsible for that. The woman at Mac's bar is.
I'm definitely not responsible for that, correct?
Right. Just like you're not responsible for the cuts to her wrist, right?
Yes, for sure.
Because the dog did it, right?
She sent me a text saying that, yes.
Right.
I'm assuming you've seen it because you had her phone.
Sir, only answer questions that are asked of you. Did the dog incident happen at the same time the bar incident did?
No.
No. How far apart were they?
It was a minute. This one, the bar incident was when we were together. I'm not sure. I don't know.
And so the dog incident when you guys worked together, right?
Correct.
So are we talking months?
I don't know.
Don't know.
Whose dog was it, sir?
Her friend's brother's dog.
Who's that?
I don't know her brother's name, but it was the friend Minnie, her best friend.
You didn't cause those marks on her arm, right?
I could have, yes,
You could have.
yes.
How about those?
Yeah, they look like hand marks.
Even that there? That still you think is just from a hand, right?
Scratch, yes.
But this one wasn't you.
No, definitely not.
And this happened when you guys weren't together anymore, right?
Yes.
Got it. So how come these photos are taken at the same time, in the same place, on the same mattress, while she's wearing the same pants?
Objection, Your Honor, speculation.
It's not.
Well,
It's
he's allowed to
observation.
answer. I'm gonna overrule that. Sir, can you answer the question?
Yes, we didn't sleep with sheets on the bed, so that was not taken the same way.
So the fact that she's wearing the same shiny black pants in every one of these photos, the jury shouldn't take away from this that these photos were taken at the same time, right?
Yes, correct.
Okay, so the jury shouldn't take from this that these were all injuries she had at the same moment in time, right?
Can you go back to the wrist?
Yeah, you got it. Yes or no, should the jury believe that these injuries were on her body at the same moment in time?
Objection to the counsel's phrasing of that particular question as to what this jury should believe. He can simply ask the witness what he knows.
Sustained, rephrase.
Absolutely. Your testimony is that despite these appearing to be from the same time, that injury happened when you guys were no longer together, and these injuries that you seem to have caused her weren't close in time, right?
Correct.
Got it. You also want this jury to believe that you did not choke her, right?
Yes.
Because if you had choked her, she would have called the cops, you would have went to jail, right?
Correct.
And you don't remember going to jail for choking her in 2021, right?
Correct.
So if officers were to testify that you were arrested and charged for it, they'd be lying, right?
Yeah, I don't recall.
Great. So if I were to pull up court records showing that you were charged with it, a complaint with your name on it, the date of January 24th, 2019, and the charge of assault by strangulation or great bodily harm and domestic violence for Alyssa Clark, that would be fabricated as well, right?
Are you talking about 21 or 19? Because you just said 2 years.
My apologies. January 24th, 2019. You said.
I was arrested for domestic violence I thought you said.
And strangulation, right?
One at a time.
I don't know.
You don't know. You busted her ribs in May of 2020, right?
No,
No. You broke into her home like you promised to do in the text messages on May 25th, 2020, right?
absolutely not.
You definitely didn't choke her out that day, right?
Correct.
You definitely didn't hit her again in the ribs, right?
No,
You definitely didn't grab her nursing scissors and try and slash her wrists with it, right?
definitely not.
Definitely not. You definitely didn't choke her out again in June, right?
Correct.
You definitely didn't, between June and November of 2020, stuff a gun in her mouth and threaten to kill her, right?
Never possessed a gun with her. No.
Never because it's the gun.
Never possessed a gun while I was with her.
Just like you didn't possess any when Detective Brandon was interviewing you, right? Because you told her.
I don't know what I told her.
Right, you could have lied to the police. I forgot that. You definitely didn't rape her while she was asleep, right?
100% no.
100% no. You definitely didn't tell Detective Brandon that there was a video of you two having sex and you deleted it, right?
It's the video of her giving me head. I probably was referring to. That's the only one I have on my phone. So that's the only one I could have referred to.
So that's the one that you say is deleted.
It had to be. That's the only one that was on my phone.
So the only video that you have taken of her having sex is the blowjob video. That's what you're saying.
Yes.
That's what you're saying. And that's why we know that the other ones have to be photographs, not screenshots, right? Because otherwise they'd have the little bar at the bottom.
Yes, she alluded that they were.
Great. Thank you, sir, for answering my question. You definitely didn't, while she was unconscious, force yourself inside of her vagina, right?
Never.
You definitely didn't put a sex toy into her anus, right?
I never.
Yes, sir, no.
Never used a sex toy.
Yes or no?
Sir, you need to answer yes or no.
Okay. No, absolutely not.
Absolutely not. You definitely didn't post her social security card onto Facebook for the world to see saying, I'm willing to sell it for $100 because you wanted to sell it, right?
Correct.
Right, because no one hit your inbox up, right? That was your answer earlier. That shows you weren't trying to sell it because no one hit up your inbox.
No, I wasn't going to sell it at all.
Right, of course not, because you're not engaged in that behavior, correct?
With selling my baby mamas, no.
Oh, I'm sorry. So you're okay selling other people's information, just not your baby mamas, right?
Not selling other people's information.
Can you say that again?
I'm not selling other people's information. I'm sorry.
You're not engaged in that type of behavior, right?
I don't recall.
Of course not. And you want this jury to believe you that you know for a fact you didn't commit these crimes, right?
I never.
Yes or no?
What'd you say?
You want them to believe you as you sit here on this stand and say, I don't remember anything, but I know I didn't commit these crimes I'm charged with, right?
That's not what I'm saying.
I don't think there's anything that could possibly be gained by me asking this man more questions. I have nothing further.
Thank you. Redirect.
Yes, Your Honor, and I'd like to put an objection on the record. We're all familiar with Mr. Pfeiffer's zealous advocacy, but those comments he adds after the witnesses answered, I object to them.
Counsel, you do need to be careful and to not add those comments. They shouldn't be in the record. Thank you.
Absolutely, Your Honor.
You may proceed.
Brooks I think counsel referred to something called a fraud box.
Yes.
Did you understand what he was referring to?
Yes.
Okay. And on his insistence, you were answering most of his questions yes or no. Is that fair?
Yes.
Was there something else about that fraud box that you thought was important?
Yes.
What was that, sir?
That's just what got me into being entertained and wondering about fraud. So that was a big part. Yeah.
I heard you.
Okay.
I didn't understand you.
I'm sorry about that. Yes, it's a big part because when I found that box, that's what got me interested in fraud. So that's when I started like Googling, looking into it.
Did you profit at all from anything having to do with that box?
Absolutely not.
Did you return any of those IDs?
No.
Did you turn them over to law enforcement?
No, they haven't. No,
I understand that, but when you
No.
found them, you didn't think to turn them over.
no, no.
Thank you. You may proceed.
Thank you. The,
Let me put it this way. If you found those items in the box at the new place that you had moved into, what caused you to then actually download an app and do additional investigation or exploration with respect to that endeavor?
I don't have a real answer for that, other than the fact that I was curious about learning about the fraud, because there was so many IDs and social security numbers in there.
the court asked you a question about, did you contact law enforcement? I'm going to go out on a limb and suggest that that was for the purposes of turning that material over to them, and perhaps they could get it back to the owners. Did you not contact law enforcement for any other reason?
Correct.
Why else did you not?
Honestly, there's no other reason besides just being curious about looking into fraud.
Right. I'll ask you directly. Were you concerned about being accused of something if you had turned over those items to law enforcement?
Yes.
On the other hand, you didn't destroy anything that was in the box, did you?
No, I did not.
The security camera footage we have looked at a couple times now, it's in black and white, is it not?
Yes, it is.
And then you indicated that, in fact, that's you that we're looking at, correct?
Correct, yes.
And that's the residence over 2700 Eaton Rapids Road, yes?
Yes.
Thank you. Whether it was at that time or another time,
Earlier in the day, or
some other time, did you enter that residence on that date?
No, I did not.
Is it your testimony that she was home or not home at that time?
She was on.
And you know that how?
Her car was there and the room light was on.
Okay. You've answered a great number of questions Tuesday and today from both attorneys. Are you satisfied that the answers that you've given have sufficiently told the jury everything you'd like to know, them to know about this case?
Yes, as far as what I was asked, yes.
Right. I'm going to insist on limitations, but what else would you like the jury to know that doesn't have anything to do with any of the questions you've been asked so far?
I would like them to know that even though I'm in these clothes, I still go to jail. When I leave from here, I come from jail. I've been incarcerated the last 18 months. I lost everything. I lost my house, my car, my job. My father passed away. I was hospitalized for 10 days, found out I had Crohn's disease.
And at this point, I'm going to object as none of that should have been presented to a jury at all, but he chose to do it. None of this is relevant here to what we're here for today.
Response?
I did not know what his
Answer would be, I agree that the court will instruct the jury there not to use empathy, sympathy, pity, something like that in deciding.
Sympathy, empathy, whether he's incarcerated or not, all of the things that he's mentioned While they may be interesting, they do not go to prove or disprove any element, and sympathy or empathy is not an element of any of the crimes he's charged with.
Yes, Your Honor. Thank you very much.
Thank you,
That was my last question.
thank you.
I would ask that it be stricken.
So struck. May this witness step down. Oh, I'm sorry. Does the jury have any questions? Number 7? All right, council, let's go in the back and discuss this briefly. You may all be seated. We'll be back in just one moment.
Great, thank you, Brian.
We don't have to initial.
No,
No, okay. Judge has to initial, not us.
I did it. All right, we've returned. Thanks for those few moments. All right, sir, a couple more questions for you. You have personal knowledge, and by personal knowledge, I mean something that you actually know, not that you were told, not that you guessed, you like saw it with your own eyes, your personal knowledge, okay? Do you have personal knowledge that Ms. Clark is making these claims because of your relationship with Minnie?
My personal knowledge would just be yes. I would say yes.
Oh, how do you know this?
The acts she did afterwards. Things she did.
Which specific acts leads you to that conclusion?
Trying to sleep with my father and close friends. And trying to put me in jail.
Okay. Do you have personal knowledge of how or when Alyssa became aware of your relationship with Minnie?
No, I don't know. It was probably 20.
I don't want you to guess.
Yeah, like, I don't know.
Did she walk in the room when you were having sex? Did she see you two in a restaurant? Was there some event that happened that you recall or no?
Yes, her friend told her.
How do you know that?
I was with her when she sent the text.
So you saw a text that was sent to her that told her about the relationship?
Yeah, she showed me.
Does the jury have any additional questions? Thank you. On behalf of the people, any follow-up?
These are once again things you are speculating about that you didn't actually see. You didn't see her receive the text. You didn't see her try and sleep with your father, right?
No, I seen the text. I was with her.
That she received it.
Yes, I was with her.
You were with her when she received the text.
Yes.
And you were with the person who sent the text.
I wasn't with the person who sent the text.
Oh, so now you weren't with the person who sent the text. You were with Alyssa when she received it. That's what you're claiming now.
That's the only thing I claim.
Right. And for all of the other things you just said, it's just you speculating, right?
No, she sent it to me.
He's never going to answer. I have nothing else.
Well, I think that's his answer. Counsel, anything further?
No questions, thank you.
All right, any further questions of the jury? No, sir, I can't have you just blurt out. You have to answer questions. Okay? May this witness step down?
You may, Your Honor. Well,
No objection.
Thank you. On behalf of defendant, any additional witnesses?
Thank you for asking, Your Honor. No, the defense rests.
On behalf of people, rebuttal.
the people called Detective Sarah Brandon.
Thank you.
Sir. Two demonstrative exhibits. This is one.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, the whole truth, nothing but the truth, under penalty of perjury? Yeah, thank you. Put your hand down. Pull the chair right up to the microphone. When you are comfortable, please state and spell your name for the record.
Tara Brandon, Tarabbrand.
Thank you. Did you two need a minute?
No, I believe that was sufficient, Your Honor.
All right, thank you. Counsel, you may proceed.
Thank you.
And let's keep this to new information. She's already testified quite a bit, so let's
Yes, Your Honor.
Thank you.
Are we still on the HDMI?
Yeah, I think so. We might find out.
Detective, during the lunch break, You created two demonstrative exhibits that are listed as people 70 and 71. Is that correct?
Correct.
What are these?
One is a video I took with my city issued iPhone. Another is a screenshot from that video.
Do you appear to accurately reflect what you took?
Yes.
People seek to admit and publish people's proposed 70 and 71.
Any objection or voir dire?
Neither, Your Honor, thank you.
Admitted?
And people 70. All right, so that was people 70. That wasn't to capture anything, it was just simply to make a video, correct?
Correct.
Did you then take a screenshot of that video on your phone?
I did.
People 71. Is this that screenshot?
It is.
Does this, anywhere on it, have a bar at the bottom showing the video?
No.
Does it have a play button in the middle of it?
No.
And this is the screenshot that you took of that video we just saw.
Yes.
So, detective, are people able to take screenshots of videos on their phones without having any of the things on them that the defendant claimed?
Yes.
Thank you. Now, you performed an interview with the defendant in November of 2024, is that correct?
Correct.
Did he appear to be under the influence?
No.
Would you have performed an interview with a defendant if they were under the influence?
Absolutely not.
Why not?
Because you're not gonna get any kind of accurate statement, and it needs a lot to be argued in court if they are under the influence.
Was there any doubt in your mind that he was, for lack of better words, sober?
No.
Did you talk to him about where he has been living?
Yes.
And what did he tell you about that?
That he lived on Millstone for 9 years, and prior to that, he lived on Larned, and that he'd been living on Wilson for about 6 months.
What did he say about who he shared those addresses with?
His mother on Larned, his grandmother on Millstone, and by himself on Wilson.
I'm sorry, Your Honor, I didn't understand the last, the third.
Why?
Witness said.
By himself on Wilson.
Did you hear that, counsel? By himself on Wilson.
Yes, Judge, thank
Thank
you very
you.
much.
Could you bring the mic just a little bit closer?
Yes.
Thank you. Did you then inquire further to confirm that information with him?
Yes.
Did he double down?
Yes.
Did he ever at any point mention even living with Alyssa at Millstone?
No.
Did you ask if anybody else lived there?
Yes.
And what did he tell you?
If I'm remembering correctly, a cousin briefly,
But not Alyssa.
not Alyssa, no.
Did he mention if anyone else lived at Wilson?
He said he was the only one that lived at Wilson.
Did you talk to him about a firearm?
Yes.
And let me ask you this. Had the searches already been conducted before your interview?
Yes.
Okay, so you already knew what was there.
Yes.
What happened when you asked him about firearms?
He said that he had not been in possession of any firearms since 2019 when he was arrested for his CCW charge.
Did you ask him about if there would be guns at your location?
Yes.
And what did he end up telling you?
He told me there would not be.
And just so the jury understands, and they may, but so we're clear, CCW means carrying concealed weapon, correct?
Yes.
Thank you.
Did he ever mention living at Eaton Rapids Road at any point?
No.
Did you talk to them about Alyssa?
Extensively.
How did he describe his relationship with Alyssa?
Rocky from the beginning, but he didn't really actually want to be with her. They'd only been involved for a month before she got pregnant, and he had no desire to be with her. He wanted to be with the other woman who he had impregnated at the same time.
How did he describe his relationship with Alyssa? How did he view Alyssa?
I don't remember the exact wording he used, but basically backup when he wasn't with his preferred woman.
Did he call her a rebound?
If not that, something to that effect. I don't remember the exact word.
Mr. Pfeiffer?
Yes.
Thank you.
Did he describe how frequently he would see Alyssa when they were together?
He said a few times a month.
A few times a month. So not living there every day.
No,
Did you ask him about GPS on the victim's car?
yes.
And what did he end up saying?
He said he had no idea what I was talking about.
Did you ask him if he had ever messaged her about that?
Yes,
And what did he say?
no.
Did he talk about having a relationship with Minnie James?
Yes,
And what did he say when that relationship started?
he said it started in the spring of 2023.
And did he say that's when he was sleeping with her?
He said a few different things. That was one of them.
Did he say if he was still in a relationship with someone at the time of your interview?
Yes,
And what did he say?
that it was Minnie and they had a child on the way.
Did you ask him when he last talked with Alyssa
Yes,
or contacted Alyssa?
yes.
And what did he end up telling you?
I believe it was the end of 2022 was the last time he claimed to have had any kind of contact with her.
Was the last time what?
He had any kind of contact with her.
And did that end up being true?
No,
How about the claim that he didn't have any guns anywhere? Did that end up being true?
no,
Did you find videos of him with firearms?
yes,
How many? Ballpark.
hundreds. There were thousands and thousands of files on the iCloud.
Did these photos or videos appear to be in a recording studio?
Some of them,
How about the ones that weren't? Where would he be when you saw him with these firearms?
some of them I recognized as the bedroom in Millstone. Because I was there doing the search, so I went into the bedroom. Various kitchens. Lots of places. There, like I said, there were hundreds if not thousands.
In vehicles?
Vehicles, yeah.
At some point, do you ask him about videos of him and Alyssa?
Yes.
And what does he end up telling you?
He told me that only one video existed of them having any kind of sexual contact, that she knew it was being recorded, and that it was about 10 minutes long. And he had since deleted it out of respect for his new relationship.
Now, you've already testified about the iCloud and how you're not able to see if things are deleted, right?
Correct.
Were there still lots of other videos of him having sex with other women on there,
Countless,
including with the use of firearms?
more than one.
Did you also talk with him about the post that happened
Yes,
with pictures of Alyssa?
yes.
What did he tell you about those photos that he posted
He said they were screenshots from the video that he had deleted.
of him and Alyssa?
Yes,
Did he tell you that Alyssa was actually awake when he took that video?
Yes, because he was referring to the oral sex video.
Because he said those photos that he posted were from that same video.
Yes,
When you reviewed the photos in the video, did they appear to be from that video?
no,
Did you ask him about if he posted the victim's social security card?
yes,
And what did he tell you?
but he did not.
Did you later confirm that he had indeed posted it?
Yes,
Now you saw in his iCloud Telegram chats that he was in, correct?
yes,
Under the name Scam Man.
yes,
Now you heard him testify that he was on there just because he found this box of people's IDs and social security cards, credit cards, and it just got him interested in scams and identity theft, right?
yes,
Just as an entertainment thing is how we refer to it towards the end there, correct?
yes.
From your view of his actions in those Telegram chats, did it appear to be for entertainment purposes?
No, there was bartering happening, instructions back and forth about how and where to access different things.
Thank you. Did you talk with Mr. Brooks about Alyssa drinking?
Yes,
And what did he tell you?
that she does not drink that often. And he doesn't like to drink with her because she can't hold her liquor.
Is that what he testified to in this trial?
No,
Did his testimony line up with what he told you in November of 2024?
barely at all.
In between his statements to you that there was a video of them having sex, but he just screenshotted it. Actually, let me go back. Did he talk about them actually having sex, his penis inside of her, on the video that he claims he deleted?
Yes, he said they had sex.
So in between him telling you these things, that there's no gun, there's no social security card posted, that he barely ever saw her, that he's never been to Eaton Rapids, she's never lived with him, and testifying this week, two pretty different stories he was telling, right?
Pretty much the opposite.
And in between those two stories he's told, he saw Alyssa testify.
Yes,
I have nothing further.
Cross,
Yes, Judge, thank you. With your help, I'm going to try to take who said what out of the picture and just talk to you about what happened, what you did, okay?
okay,
Thank you. Law enforcement, whether it was you or somebody else, somebody seized Mr. Brooks' cell phone. Is that a fair statement?
yes,
And it was taken somewhere to be analyzed in some fashion. Is that also true?
yes.
Is that something you did or participated in or someone else?
I collected his phone from his property in jail, and then I took it to the computer crime unit at the state police to have it extracted and analyzed.
Did you participate in the actual extraction of data?
No,
Okay, and well, let me ask you this. There was a time when if you dropped something off at the state police crime lab, they fill out a little form and asked, you had to indicate to them what you wanted them to do with it. Does that still happen?
yes,
Okay. And is that, whether it's a form, is that something that you did?
Yes,
And do you recall today what you asked the crime lab to do with Mr. Brooks' telephone?
I wrote a list of the things he was charged with and then asked them to find things relevant to the charges that were issued.
If you recall, did you ask specifically to see whether there was a video? The one that was described by Ms. Clark, where she was unconscious and so on and so on.
Yes,
And what was the result of that?
they could not find it.
I'm not asking you as an expert. Is it your understanding that the Michigan State Police Crime Laboratory has the ability, even if as a consumer I hit delete, it's still there?
I think at this point, he is asking her to testify as an expert.
Well, based on your knowledge, and is it working as a police officer, just using your own, do you know?
It's my understanding that it depends, but on what, I have no idea.
Thank you.
Thank you. You're confident that in some circumstances it's possible?
Yes,
Thank you again. All right. I heard you talk about videos, sex videos, and firearms. That right away just sounds not good. What did you see? What are you talking about? Videos with sex and firearms?
I observed a video of him having sex with a woman from behind. And he produces a firearm and points it at the back of her head. And when she goes to adjust, he pulls it back pretty aggressively, in my opinion,
Pulls what back?
the firearm.
From where?
He had it extended out in front of him, pointing it at the woman. I don't believe it to be the victim.
You,
There was more than one, if you want me to talk about the other one.
well, right now, from what you could observe, I know you weren't there, from what you could observe, did it appear as though the female half of that sexual interlude was able to see the firearm?
No,
Okay. And I think you and I crossed this bridge the other day. It's difficult to be 100% sure as to whether any firearm you see in a video is the same one that came in that box earlier.
I suppose definitively no.
Okay. It might look like it, might be the same size, might be the same caliber, might be everything else the same, but you can't say for sure.
Correct.
Thank you very much. Do you have a memory today as to how many videos there were involving Mr. Brooks and Ms. Clark?
Not specifically.
Okay. And one of the last things I think you answered to council's question was whether Mr. Brooks told you during his interview that he and Ms. Clark engaged in some type of a sex act on the same day that the photos were taken of her with her eyes closed and so forth.
Yes,
Did he tell you that it was while she was blacked out or unconscious, or was it a couple hours later?
all he said was that she was awake.
Okay. Thank you. And I'm going to go sit down, but as I do, I just would like to ask this, if you know, this examination by the folks over at the crime lab. Did you, as the investigating officer, receive some kind of a report?
Yes,
And in that report, did it list all of the various photographs and videos and so forth? Or
Some of
no?
them,
Okay. And was the same thing done with Ms. Clark's telephone?
no,
Okay. Is it fair for me to ask and for you to answer that whether it's text messages, photographs, anything from her phone, she presented, um, that you did not have her phone inspected and make selections of certain things? She offered those things that we've seen.
she sent me screenshots. Typically, I try not to confiscate victims' phones because we have to dump the entire thing. They're already traumatized enough going through this entire process, so I try not to do that if I can avoid it. And when I did dump his phone, I got plenty, a lot of the text messages and screenshots she sent were also in his iCloud. So I didn't find it necessary to also get her phone. Had I got nothing, I would have, but I'm gonna go offender first.
Okay, you answered a question that I didn't ask, that was why. But the only thing I want everybody to understand is that you made the decision, or law enforcement made the decision as to which parts of Mr. Brooks' phone would be relevant in this particular case.
Yes, I made that decision.
Thank you. And it was Ms. Clark who made the decision as to what she thought would be relevant from her phone in this case.
Yes,
That's all I have, Your Honor. Thank you.
Redirect.
When a phone or iCloud is turned over to Michigan State Police, you do list certain things you're looking for, correct?
yes,
Do they still dump the entire phone?
they have to. There's no way to do partial phones.
So the entire phone is still turned over and presented.
Yes,
It's not the Michigan State Police cherry picks what to provide out of the phone, correct?
correct.
I have nothing further.
May this wait a minute, does the jury have any questions? Seeing no hands raised, may this witness step down.
She may, Your Honor.
Without objection.
Thank you. Any additional rebuttal witnesses?
None, Your Honor.
People close?
People do.
At this time, we are going to have closings. Do you need a moment?
15 minutes. A lot developed this afternoon, but I don't need a terribly long amount of time.
Would you like a few minutes before we go to closing?
I would, Your
All
Honor.
right,
And
let's
I would
take-
also, I'm sorry. Yeah, I would like the three of us to visit.
All right, thank you. See you in 15.
No, we have the preliminary matters we need to address on
Oh,
the record.
that's right, okay.
I'm grabbing the updated jury instructions in a moment here.
Sorry, I'll speak from wherever you'd like. I'm just trying to put these in order. Did Brian not bring the set of instructions?
Don't think he brought him.
What are you looking for?
The new set of instructions. There are a couple of things that had to be changed. I think he's printing them right now.
They might
Yep.
still, I don't know if he's still printing
Okay.
them.
They were purely technical.
If you're gonna walk around, are you gonna? walk around?
I'm not. I'm gonna stick by the podium to the best of my ability.
All right.
We do have wireless mic.
Yeah, you could walk around with a wireless mic. Why didn't you should have had him do that before?
I should. It's gonna be a problem. I've got the wireless mic in my table. I'll make sure I put it on.
You have it there?
Yep.
Okay.
Yeah, since my table's microphone hasn't been working.
Right,
Oh,
we've got
yeah,
a work order in.
Yeah, because Brian has, that's why.
Hmm?
Brian has the,
Is it on now?
no. He has them booked off for both tables.
The mic's off on those tables? We tried to turn them on, we came to fix them and they said they're not working.
There
Yeah, the whole
Well, no,
place,
they might be on, maybe they are on.
yeah, the whole
But they're
place
not.
has to come, we already had them.
You know,
trying to
these
fix it.
conditions
The whole
Mr.
place
Friggin'
has to
small
come.
talk is killing all the trees with this.
Sure.
Are we ready now?
Yes.
Okay. Thank you. We're back on the record. And at this time, we're not going to bring in the jurors because I understand that there have been a few changes with the proposed jury instructions. Is that correct?
That's correct, Your Honor.
Okay.
There are changes that have been agreed to, and then there are some that the defense is requesting, people are opposing. Figure we just start with the ones that we've all agreed to.
All right.
The people are modifying the date range for counts 9 and 10, the felonious assault and the accompanying felony firearm.
And that's been stipulated too. Is that correct?
That is correct. Your Honor.
Okay,
So
thank you.
it now reads between June 2026,
So,
June 2020 and November 2020. I certainly hope that's what I put there.
Is it wrong already?
Hold
What?
on, I put the.
I'm sorry, what page is that? Or what charge is it?
9 and 10.
Okay, 9, we have June 2020 and November 2020, correct?
Great, I just misspelled it in my email. We're good.
Okay, I've got it right in front of me. And it has page numbers, so,
I drank 2 Red Bulls, a coffee, and I got electrocuted. Don't give me this heart attack.
We can use a bit more. We're adding in 20.27, that being the consent instruction, because while the defendant is still, and the defense is still that the sex act did not occur for count 13, the criminal sexual conduct in the first degree, technically, there is evidence on the record that he told Detective Brandman that the sexual act that was in the video was consensual. And therefore, for appellate purposes, I believe that it is required to be in the jury instructions.
all right, so that is page 29, it's 20.27 consent, that is in the instructions.
And then the people are also changing the theory of the criminal sexual conduct in the first degree. Instead of object into the anus, it's being changed into penis into the vagina. Because again, that is what he said to Detective Brandon on the video. And while I could technically add a completely separate count of criminal sexual conduct in the first degree for that, I think it's just significantly simpler and easier to modify the theory of count 13.
Okay, thank you,
without objection on that issue, Your Honor, thank you.
thank you. Okay, next,
That is all that we have. Oh, and then there was one that was erroneously in there about behavioral expert that was caught and removed.
What did you just say?
There was an erroneous instruction in there about a behavioral expert testimony that
Oh,
was from a previous trial.
okay,
It was caught and it was removed.
all right, thank you.
Thanks very much, Your Honor. I have a couple of concerns I'd like to express. The first is with respect to the count of home invasion in the first degree. My reading of the statute, as well as my reading of the instructions, counsel is going forward on what I'm going to call two separate theories. That is to say, whether the defendant broke and entered the residence or whether he entered without permission. I'm of the opinion that the jury should be instructed that if they find guilt beyond a reasonable doubt, it must be by one of the two theories rather than splitting, some saying it was breaking and entering and others saying it was unlawful entry. I believe they have to be unanimous as to which of those two. This second issue is with respect to criminal sexual conduct in the first degree. I want the record to reflect that I have considered the lesser included offense of the third degree, but I'm not asking for it. And the reason is because it has been my client's position that there wasn't any.
Okay,
And so I don't think it would stand muster to the Court of Appeals if it was appealed for that reason. I also would like this record to reflect, and for the overworked and underpaid attorneys and clerks at the Court of Appeals, that yes, there were search warrants involved in this case, and yes, I think an argument could be made that they were general warrants, but I'm also aware of I think it's a 2025 opinion by the Michigan Court of Appeals that states that as long as the law enforcement or the crime lab follow the protocol, everything from placing the device in airplane mode to the extraction of the data, if they have preserved an exact copy, then they can ask for a second search warrant and go back. And so I intentionally did not challenge them because I'm aware of that other case. And so I just wanted to indicate that on the record.
thank you.
The last concern I have, Your Honor, is the wording of our instruction 3.20. The most significant challenge I'm placing on the record is the very last sentence. It currently says, you may find the defendant guilty of all or any combination of these crimes or not guilty. Number one, I think that's confusing. And number
Sir,
two,
what page are you on?
I'm on page of the new, I'm looking at what is 54 of 100, but I think it's a different page now. It's instruction 3.20.
I'm just looking for it.
Single defendant, multiple counts, more than one wrongful act.
Okay,
Page 56.
I got it, page 56, yes.
Okay. The very last sentence, I think, is at least confusing, and I think it's prejudicial against any defendant, including my client. You may find the defendant guilty of all or any combination of these
Well,
crimes.
you know, I don't want to interrupt you there because I have often thought that. I appreciate you mentioning that. How about we change it to you may find the defendant guilty of all, none, or any combination of these crimes or
Thank you.
not guilty.
Thank you, Your Honor. Consistent
Because-
with the verdict form where traditionally we list not guilty first, I'm respectfully suggesting you may find the defendant not guilty or guilty of all or any combination of these crimes.
The people have no objection to that.
All right, so I'll change it to you may find defendant,
Not
Guilty,
guilty or
not-
guilty
yeah, not guilty or guilty
of all or any combination.
of all, none, or any combination of these crimes.
The people have no problem with that, Your Honor.
Yeah, I appreciate you mentioning that, because every time I read it, I think that's weird.
No,
But that's the Supreme Court problem, so we'll change it, maybe they'll get the message. Thank you for raising that.
Thank you, Your Honor. It was the penalty one that always disturbed me, but that was corrected, so now
Have you all agreed on the verdict form? It looks appropriate?
I believe so. Yes.
Okay.
Unfortunately, I do. Trust me, I would love for them not to be,
Okay. Anything else?
but I'm stuck.
So we are at 3:45. We can do closings and I can read these in the morning, or I can do all this. I suspect by the time you get both done with closings, I'm not gonna have time to read this and then they're gonna deliberate.
I'm happy to do whatever we're able to do today.
Then let's get to closings and see how much time we have. It may very well be that tomorrow morning I open up this and then they deliberate.
Absolutely.
Because this is, I don't know, how long did it take me to read the first set?
Good
Probably
chunk.
40 minutes, 45 minutes.
I think so.
Let's see how well we do. It might be fresh to give them these, first thing in the morning.
I'm
So-
happy to do the most with the time we have.
All right, then may we bring in the jurors?
Yes, Your Honor.
Your Honor, just to make sure I'm clear, this court is wanting to, or is not wanting to have the council give our closings and then immediately give.
I want you to give your closings and then I'm gonna see how much time is left. And then I will either read these and send them back, or we'll just end then and go in the morning and we'll read this in the morning.
I understand. Thank you.
Okay, thank you. The jurors, please. Mr. Pfeiffer, you have your, okay, have you spoken into it? Come forward here and see if.
I'm
council can-
hoping I've been speaking into it the whole time.
Can you hear, is that good?
I can actually.
All right, we should have had you put that on the whole time. All right, very good. That way you can move around, because I know how much you like to bounce around the courtroom. All right, you feel free now, you have that mic on.
I like to call it pacing.
Pacing, uh-huh.
With my
Okay.
thanks to the court and to Mr. Pfeiffer, thank you very much.
Thank you. Should I knock on the door?
Good now, Judge?
All good.
All right.
Thank you. You may be seated. On behalf of the people, closing at this time,
Yes, Your Honor.
you may proceed when you're ready.
One moment, I apologize. Can we? He's gone. Okay. I'm gonna see if it's still on HDMI.
All right.
I should have caught him for you.
Are you good? You're good.
We're good.
Thank you.
Okay, that's good. Good afternoon. I told you at the beginning of all this, this was not going to be an easy trial to sit through, and I'd like to think that I kept true to my word. But that doesn't mean that the decision here is difficult. What you heard in this trial was Alyssa tell you in pretty specific detail what that man did. That was corroborated by the text messages, by his messages to other people trying to get someone else to go beat her up, by the surveillance videos and the medical report showing she went to the hospital on January 24th, 2019, because she had just been a victim of domestic violence. Things that I didn't even know existed. She was more on top of this than even I was. She did not falter when questioned about specific details from different events. She said, I don't remember when this one happened, but this is what happened. She told you in detail about what she saw in that video, which is then bolstered not only by what was found on the defendant's iCloud, but by what the defendant told Detective Brandon. There was a video, and he deleted it out of concern and respect for his new girlfriend. Didn't delete any of the other ones. Didn't delete the ones where he's shoving a gun inside a woman or pointing one at the back of her head. Because that definitely wouldn't offend his new girlfriend, but that one would. So he deleted it. Is that reasonable? Is it reasonable to believe that he was high that day, the detective had no idea, and that means he doesn't remember a single thing that he said to her? No. Is it reasonable to believe what he told you? You have to figure out which version of what he told you, because that shifted. Was it reasonable to believe that Alyssa has not testified about this multiple times, spoken to multiple officers, and is making all of this up, is fabricating text messages, is fabricating evidence because he slept with her friend 5 years ago now? There is no reasonable doubt here that that man abused her, beat her, and violated her. There's no reasonable doubt because you could have been able to see with your own eyes how he would treat her. You are my property. I own you. The only way out is death. I'm coming for you. I have a GPS tracker on your car. I know where you are. I'm coming for you right now. Get ready. I'm going to kill you, you bitch. I love you so much. Come on, let's just do that. I'm going to kill you. I swear it on my children. I swear it on the Bible. I'm going to kill you. I don't think he wanted to kill her. I don't think he meant to kill her. I don't think he intended to end her life. I think he wanted to make her believe that. I think he wanted to scare her down to her last fiber of her being, that he could kill her at any time. I think he wanted to have someone to abuse, to have power and control over. in any way he saw fit in that moment. You heard from Melissa. You heard from officers who searched this place, who found firearms, but in telling Detective Brandon, nope, haven't touched any guns since 2018. Oh, and yes, there's lots of videos of me with firearms, but no, those were just props. Those are just props in music videos. Except you heard testimony, the firearms they found at the two locations weren't props, they were real guns, including the one at Millstone. It was broken, but it was real. This wasn't some BB gun, this wasn't some plastic prop. This was a firearm. You could see the parts of it that were broken that were sitting next to the gun in the case. That's not a prop. And then the firearm that he was hiding under his bed. Don't worry though, that was definitely for safety purposes. Not going to use the gun box with a lock the other place that I can replace with any lock on this earth. I could just go down and drop $3 on one. Nope. Because, keys jammed. What could I do? Also, not going to put it up on the high counter they talked about looking around when the magical box of fraud documents dropped down. No. In the bed. Closer to the ground and the height of children, in the bed. How could I possibly have known that the gun was stolen? Yes, I bought off a man who I refuse to name. I don't think anybody missed that. Who'd you buy it from? I'm not telling. You have to. I don't recall. Is that not the entirety of the defendant's testimony in a clear 10-second nutshell? I don't want to answer this question. I don't want to tell you what happened, so I don't recall. By the way, went back and checked. When I asked how many times do you think you said I don't recall, it was 55. And that was only about halfway through. He can absolutely recall the parts he wanted to. It's not about memory. It's about what do I think is going to help me the best right here, right now. What's going to help me the best when I'm being interviewed by a detective about crimes against Alyssa Clark? I barely know her. We've got kids together, but it's not serious. No, I've never lived with her. What? No, I only see her like 3 or 4 times a month. That's it. And that's when we're in good. So, no. And then what does he think is going to help him here? Look, we were together. I was living there, but she's crazy. There's a reason that they don't line up. One set of statements was made before he knew what the evidence against him was. Before he'd seen Alyssa testify twice now. While he refused to admit it, you all heard his testimony on Tuesday. The first I ever heard of a video showing me raping her unconscious body was a week before trial when I was reviewing discovery. He refused to acknowledge that that's what he said here. Steadfastly denying it. You all heard him. The first I heard about this rape video was a week before trial. That's not true. As was brought out through my cross-examination, when he would answer my questions, he was at the preliminary examination back in 2024, December of 2024, with the lower court where Alyssa testified, and he heard her testify about this video that she found of him violating her. Well, that doesn't help him in this moment, so now it's no, I never said that on Tuesday. None of it lines up. Even with just himself, it doesn't line up with his own statements. He tells Detective Bramman, no, I deleted the video. Those things were screenshots of the video, and I I deleted it, but it was definitely consensual. We had sex. I had my penis inside of her, but no, I got rid of it out of respect for my new girlfriend. They can't be screenshots because any screenshot has the video showing at the bottom of it or a play button in the middle. He testified about that, I think 4 or 5 different times. And it took a single 30-second video and a screenshot that was made during the lunch break to prove that wrong. No. I never posted her social security card online. And then when it's confronted with that in front of him, okay, yeah, I did, but I wasn't trying to sell it. He was asked, why does this post not indicate you're selling it? And his response was, because no one hit up my inbox. There was a pause as everyone realized how damning that statement was. And he then followed up with, and I wasn't trying to anyways. He would never do that, except for all the Telegram chats, which again, he has no idea why he posted the video of the box of fraud in there, and he will not look at it to see why. Do you want to look at the chats about what you were saying around when you posted that? Nope. Did you send these text messages? Nope, those are fake. Well, no, but those ones are real. Those ones are real there. How about the ones immediately after those? Nope, those are fake too. Part of your job as jurors is judging credibility. As I've already said at the beginning of this trial, what I tell you the law is, that doesn't matter. It's what the judge tells you the law is. But I have a sneak peek of what that is. Both attorneys do, because we have the instructions that are going to be read to you. So I'm going to give you a sneak peek. Witnesses, credibility. There is no fixed set of rules for judging whether you believe a witness, but they help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Did the defendant seem to be making an honest effort to tell the truth, or did he seem to evade the questions or argue with the lawyers? I don't need to belabor this point. It was clear he did not want to answer my questions. He didn't even want to tell me what month October is. There are 18 counts charged here. Not all the crimes that we heard about today. Sorry, this week. Not by a long shot. But this is what we're here for today. I'm going to go through these as best a timeline as I can. May 2020, count 5, assault with intent to do great bodily harm, less than murder. Leading up to the May 25th incident where he is bashing her in the ribs to the point that they break. And where she is so worried about losing custody of her children that she doesn't go to medical care. So let's be clear, he has been assaulting her since 2018. That's when CPS started, because of that. Why would it make the CPS issues easier if he was not around her. Because he was hurting her. An acknowledgement that she is gone back to the man who has been beating her puts custody of her children at risk. And she valued that more than her health and her safety and her pain and her suffering. Right or wrong, her priority is that she can have her children in her life. She does what she can for the pain. Wraps it up. Takes some Advil. And only a couple of weeks later, May 25th, 2020, he breaks in her door. How do we know by break-in? He opens it, it's unlocked, and forces his way inside at great speed. How do we know? It testified to it. And it also helped that he was texting her that day, I'm gonna come bust that door down. It helps that he was saying, on May 8th, in the exhibits that have been admitted, I'm coming over there, I'm gonna break that door down. I'm getting inside. And while he's tried to say, no, I lived there. I didn't break in, didn't need to break in, didn't need to force my way inside, didn't need to enter without permission because I lived there. I could come and go as I pleased. I'd drive to work, I'd come back, play video games. I had free reign. But what happened on cross? Because he was very loosey-goosey with the times until it was nailed down. His claim, not the truth, his claim is that he left there around October of 2021. He was there for 6 months. Means he moved in by his own version of events, April 2021. So he was not living there on May 25th, 2020 by his own story. In fact, he ended up saying, well, I don't know. I just have no way to know, which means he has no idea by his own second version of events if he actually was allowed to be there that day. Only there was some way that we could know which of these stories is true. Wait, we have the text where he says I'm going to break the door down. We have the text afterwards of her saying, the police got called because someone saw me running out of the house bloody. While he was there, he strangled her, he beat her, kept punching her again in the same ribs. He saw her nursing scissors on the dresser. He grabbed them and he tried to slice her wrists. She had to fight him off to stop it. And once this had started, she said, I am going to call the police. I want to call the police. And he made sure that she couldn't. He made sure that the phone he ripped out of her hands, she could not gain access to, which is why she had to flee just to call for help. June 2020. As she said, sometime in June, where he was beating her again and strangling her unconscious again. And then, a time period somewhere between June and November, he took one of his handguns and put it in her mouth and threatened to kill her. Now, the defendant also wants to try and claim, well, no, that's a prop. Pretty sure when you have a steel barrel in your mouth, you know that's a gun. He strangled her again over the course of 2020. Put his hands on her. She did not want it. And he would frequently choke her either unconscious or almost to the point of unconsciousness. And then we have the CSC in the first degree, criminal sexual conduct. Some point in 2020, to be clear, the people do not need to prove when that crime happened, just that it did. But the best she was able to narrow it down to in her memory was 2020. She had a couple of shots with him, blacked out, which, as she said, is not something that happens to her. That had never happened to her before, not just from that level of alcohol, but period. She was woken up later by him putting her in the shower. Water just careening down on top. It wasn't until looking through his phone weeks later that she saw the video. The video of herself naked and unconscious, of him moving her and throwing her around, flopping to and fro, of him putting his penis inside of her vagina and having sex with her when she could not consent to it, and then, for good measure, taking a sex toy and putting it into her anus. That's how she found out she was raped. She had to watch it HD. She told you how this affected her. She told you about how after all this from Vendrico Brooks, she ended up being,
After what?
all this with Vendrico Brooks, she ended up being diagnosed with post-traumatic stress disorder. How she would have to, you saw in the text, have to cover her arms because her coworkers were starting to notice the bruises. About how traumatic and damaging this was for her. To the point where even having to relive that incident, she ended up having to take time off of work because she was not in a good state. One of the elements for criminal sexual conduct is the first degree is what's called personal injury. That means either physical injury or mental anguish. And the evidence shows she suffered mental anguish. Once again, preview of the instructions are going to be read. Mental anguish means extreme pain, extreme distress, or extreme suffering, either at the time of the event or later as a result of it. Here are some of the things you may think about in deciding whether Alyssa Clark suffered mental anguish. Was she upset, crying, or hysterical during or after the event? Did she need psychological treatment? Did the incident interfere with her ability to work or lead a normal life? Was she afraid that she or someone else would be hurt or killed? Did she feel angry or humiliated? Did she need medication for anxiety, insomnia, or other symptoms? Did the emotional effects of the incident last a long time? Her testimony of what she has had to go through because of this clearly establishes mental anguish beyond any reasonable doubt. Then we have September of 2023, the postings. Computers using to commit a crime, personal identifying information, obtaining, possessing, transfer, or intent to commit identity theft, and intentional dissemination of sexually explicit visual materials. So the first is him posting her social security card to Facebook so someone can buy it, take her identity, and scam her. He wants you to believe this was a fear tactic. It wasn't. All of the evidence here points to the fact that he was trying to fuck up her life. Well, he'd never do that, except we have the Telegram chats that show it. He had put her ID or social security card in the box of other people's IDs. What I locally called the fraud box. One that he posted in the Telegram chats where they're committing fraud. The elements for that either did seller transfer or did attempt to. He didn't have to succeed, he just had to try. And he tried. By any amount of reasonable measure, the evidence shows he tried. And then, using computer to commit a crime, he used Facebook to commit that crime. That's done either off a cell phone or a computer. No matter which of those sources it was, doesn't matter. He used a computer to commit the crime of personal identifying information, obtaining, possession, or transferring with intent to commit identity theft. That is from the posting of that on Facebook. And then we get to intentional dissemination of sexually explicit visual materials. I am not saying that the photo of her face or of her stomach that he posted alongside that to Facebook is the sexually explicit visual materials. I'm not. I'm saying that the naked photos and the video of her giving him a blowjob that he posted to Reddit is. And while he wants to claim, no, I didn't, that's not what that means, he never actually had an explanation for why he said that. You're going viral on Reddit. Right after he said, it's up. Meaning it's up there. It's uploaded. It's up on Reddit. He's not shy about using language when it comes to, I'm going to fight you, I'm going to beat you. He showed her what he posted on Reddit, an anonymous website, unlike Facebook, and said, up there now, you're going viral, bitch. That is the intentional dissemination of sexually explicit visual materials. How do we know it happened? Because he taunted her with it. Brings us finally to November 19th, 2024, where he had a stolen gun. It was stolen. He knew it was stolen, or per the law, should have reason to believe it was stolen. He knew what the proper procedure was for buying a firearm. He had done it before. He was then got in trouble for concealing it, but he knew the proper way to go about this. The forms, the registry, the minutia that is involved with this process, the background checks. And then he bought this gun off the street with a person he refused to name that involved none of that. And he hid it in his home. He didn't hide the non-broken one. He hid, the non-stolen one. He hid the one that was stolen because he knew it was stolen, or he had reason to know it was stolen. The situation was so sketchy, he refused to give a name. He knew what that was. He knew what he was doing, and his actions once he got that gun show that. The last count here with a very wide date range, November 2018 through January 2024. Aggravated stalking. Did he make 2 or more unconsented contacts to Alyssa Clark? I think it's pretty clear from the testimony and the messages that he had to do from other accounts and friends' phones because she had blocked him, shows they were unconsented contacts, including her saying she did not want to talk to him, leave me alone. And then the other element, did it make her feel frightened, intimidated, threatened, or harassed? Absolutely it did. He was threatening to beat her. And finally, the aggravating factor. There's 2 options here. Did these include threats to kill or injure? Clearly they did. We could see them with our own eyes. And in the alternative, was any one of these contacts in violation of a no contact order or a personal protection order, an order from a court saying you're not allowed to talk to her, and your testimony from her that they were, and you can even see the text message that was from 2024. Baby, I love you so much. Again, while the court case is going on about September 2023, I love you so much. Give the kids happy birthday for me. You know, we can really sort this out. That message is the entire reason Detective Brandman got involved in this case at all. To confirm dates and times for the contacts and the no contact orders. That is what spurred and resulted in Alyssa sitting down with Detective Brandman, and then what should have been a 30-minute interview turning into 3 hours because of the amount of pain and suffering that man put her through. I am asking you to find him guilty of all of these charges because the evidence shows nothing else. There is no reasonable doubt here. People are conspiring to fabricate evidence against me. That's not a reasonable doubt in this case. He was not a credible witness by any measure of that definition. I'm asking you to find him guilty because the evidence shows nothing else. Your job is to decide what happened based on the facts you have and determine if these crimes were committed based on the law that you're given by the judge. Your job is to be critical, open, and honest with each other in your deliberations. You're required to be unanimous across all of these counts. Sorry, for each count, you're required to be unanimous on the elements. You all agreed the elements for this count were met, each one of them, in order to come back with a verdict of guilty for that crime. There are several crimes here with alternate theories. Just talked about one with the aggravated stalking. Another one being the home invasion. There are 2 theories for home invasion under the law. The first being breaking and entering. It's defined as any amount of force used to enter a building. That includes opening a closed window, opening an unlocked door. That is a breaking under the law, and then entering. Committing assault while in there, there's another person lawfully present. Listen. The alternative theory is entry without permission. Door can be wide open. Don't have permission to step through that door. That is entering without permission. And once inside, made an assault, and Alyssa is lawfully there. That is the home invasion. You do not all need to agree unanimously which one of these theories are met. Half of you can think it was a breaking and entering. Half of you can think it was just entering without permission. But as long as you all agree that one of these theories was met, you're required to come back with a verdict of guilty. That is the law. Now notice there was something that was changed since I have made this in my opening statement. That being these 2 counts. Count 9 and count 10. Assault with a dangerous weapon and felony firearm. It is not an exaggeration to say that the testimony showed he threatened her with guns numerous times over the course of 2020. But the one that appeared to be the clearest and the most detailed was the pistol inside her jaw, which she said happened between June 2020 and November 2020. So the people have amended the date range to reflect that accordingly. The other one that has been changed is criminal sexual conduct in the first degree. I told you that the theory was the penetrative act that happened was a sex toy into the anus. And I'm not saying that did not happen, but this has been changed to penis into the vagina. Why? Because he admitted to Detective Brandman that that part of it happened. he still claimed that it was consensual and that she was awake, and that those photos he took, she was awake. The photos where she has her eyes closed and where he is trying her mouth open. She's apparently awake there. Because remember, he told her this is from the video where they had sex that he deleted. But because he admitted to Detective Brandon putting his penis inside of her vagina, people thought it would be most prudent to change the penetrative act for count 13 to reflect that. Because that is not one where I can list both. It would need to be an entirely other count. And I think 18 is enough. There is nothing that can be done to make Alyssa the person she was, or the person she would have been if that man hadn't abused her, threatened her, and beat her, and extorted her. I asked her why she was here. If she knew how terrible testifying was for her the first time around. Why she's here after reporting this back in 2024. Here in 2026. She told you why. So there can be justice for what was done to her. I am asking to find him guilty of all 18 counts because there's no reasonable doubt that he is not guilty of those. I'm asking you to hold me to my burden and to do what you swore you would do. Be honest, be critical, and to use your common sense when you're evaluating the testimony and the evidence in your case. Thank you.
On behalf of defendant, closing.
Yes, Your Honor, thank you.
You may proceed when you're ready.
Thank you. I will need just a half a moment.
That's okay, take your time.
Good afternoon. This trial has not been a particularly lengthy trial as they go, a couple of days. And so because of that, I don't think it's necessary for me to go through each and every witness or each and every count and reiterate things that you've already heard or things you've already seen. I don't think that's necessary. I will touch on a little bit of that, but not extensively. One thing that I'd like to make clear immediately is that during my comments, I may say something about the evidence in the case. So-and-so told you X. If that's your memory, great. If that's not your memory of what that person said, you must go with what you recall, not what I'm recalling, okay? And by no means am I suggesting to any of you that I'm quoting the law that you are to follow. That's Judge's job, and she'll take care of that probably tomorrow. So listen to what she tells you about what the law is that you're supposed to use, not myself and certainly not Mr. Pfeiffer, although we may allude to it from time to time. All right. The first thing I'd like to get taken care of here is, I have to follow my own rules, stay in front of the microphone. What I think is the elephant in the room, and I'm just going to say it out loud. I thought that the entirety of the testimony of this trial suggested strongly childish behaviors. Oh my gosh, we've got people who are what, early 20s, mid 20s, and acting like children at a playground or at a school, just, you know, so-and-so did this, and so I did that back. You know, the name calling and all of it. That's my impression. You've got your own, I'm just sharing with you. It seemed like it to me. And I say that for two reasons. Number one, because I think it is the testimony of what did or didn't happen is childlike. We would expect adults to act differently. But I also bring that to your attention because I also think that it's not necessarily true, it's not automatically true, that childish behavior is the same thing as criminal behavior. We're focused on criminal, not lack of maturity or some other side issue. The situation is that my client, Mr. Brooks, has been charged by the prosecuting attorney's office for crimes that are alleged to have taken place over a period of years. Over a period of years. I don't know that the memory of Ms. Clark or my client or of any witness is going to be razor sharp years afterwards. So with all due respect, I'm respectfully asking that, you know, maybe we need to allow for a little bit of variance. Well, it was 2 o'clock in the afternoon. Well, maybe it was 3:30. Okay. But if it was 4 years ago, you see what I'm saying? It doesn't mean lying. Our position is that Ms. Clark, Alyssa Clark, has exaggerated her testimony. She has exaggerated any statement that she gave law enforcement. And in support of that contention, we now know that it was a police detective who looked at the materials located on Mr. Brooks' phone, and it was she who determined which portions of that data were useful in terms of bringing prosecution against my client. Whereas it seems to be undisputed that Ms. Clark's phone was not examined forensically by the crime lab, that it was Ms. Clark who went back in her saved files and hand selected various text messages, photographs, and what have you, and presented them to law enforcement, who of course passed that on to the prosecuting attorney's office, and they made a decision that 18 serious crimes were committed. And so here we are. I don't think it's a stretch. I don't think it's a stretch that if Ms. Clark had in her phone, you know, she's scrolling through and she's, there's a nasty gram from him right there. And set that one aside. And here's something else that he set that aside. Okay. So these are all negative things that I can point to that were either written by Mr. Brooks or photographs taken by Mr. Brooks or whatever it was. And I can select which ones I'm going to turn over to law enforcement. Well, how difficult would it be then to come up with a story to match what you know you're going to give them? I keep coming back to that fantastic bruise on her right thigh. I mean, that is some kind of bruise. And without being a medical professional, any of us, I don't think it's a stretch to look at that and say, wait a minute, that was a direct result of a man's fist. That was a direct result of Mr. Brooks' fist in particular. It didn't come from anything else. There wasn't any other reason why you chose to save that photograph, to take the photograph and to save it. If someone is just a natural collector of things, I'm not talking about hoarding, but you know, if you just you tend to save text messages or photographs on your phone. That's fine. But to then suggest that I'm going to need to say something that points a finger of criminality at Mr. Brooks when anyone looks at this photograph, it's going to support my oral representations, okay? And this adage of actions speak louder than words, I think that that's true. I think it's particularly true with respect to Mr. Brooks. Did he make claims of going to do this and I'm gonna do that, and I'm gonna huff and puff and blow your house down? Yes, he did, and they're all in evidence, and you can look at them as long as you want. They're all there. All right, and so it's a written word, but it's more verbal. And so what happened as a consequence? Her house burned down? No. She was killed? No. Kids were hurt? No. What happened afterwards? It just is consistent with what Mr. Brooks told you, that the only reason he was on her is because she posted sexually explicit images involving him. Okay? That's what one of the counts that he's charged with. And his attempts to get her to take it down, we don't have to agree with his methodologies, but those were his attempts to get her to take that stuff down, which she should have. And had she taken it down, as soon as she found out, oh boy, he knows about it, he's gonna go ballistic, boy, oh boy. Then why didn't she just take it down? Why didn't she just take it down? The longer she left it up, the more upset he got, insisting that she take it down. But he did not physically harm her because of that. He sent these messages, you better, and yeah, they're pretty graphic. And some of them are just, you know, the kind of message that if you got it, would prompt most anyone, I think, to comply, to say, boy, I'm gonna take that down, right now. But she didn't, and so the text messages continue. This couple of these, I just have to tell you, I don't understand, but if you, as a group of 12, are able to come up with a verdict, terrific. The first one I'm starting with is this whole idea of torture. It's the very first charge. And you're going to hear the judge tell you tomorrow that in order for you to vote guilty and to convict Mr. Brooks of torturing her, you have to find each element proven to your satisfaction beyond any reasonable doubt. Each and every one of them. If you get to the second or third element and you find that, well, yeah, that I don't think there's sufficient evidence or sufficiently reliable evidence, then you can stop right there and you mark the box that says not guilty, you go to the next one. It's not difficult. Your job is not to solve crimes. Your jobs are not to figure out something. Your job is simply to say, okay, which evidence do we find reliable? I'm reluctant to use the word believable. You do as you choose. But is it reliable? And you heard Ms. Clark testify. If you found all of her testimony reliable, okay, I'm thinking that at least some of you maybe didn't. Not 100% reliable. Not reliable to the extent that you should count on it and say, yep, that's enough for me to, I don't have any doubt, I don't have any reasonable doubt about this particular charge or criminal offense, and because of what she told us, because of what she said happened. It's just like going to the hospital. You know that little form, it said, the date that she went into the hospital, and it says the reason she was there. And yes, I saw the word domestic violence just like you did. Well, where'd that come from? Was that Dr. So-and-so after consultation saying, in my professional medical opinion, this is what this person is suffering from? Or no, it's what she told them. In the medical profession, they say, get a history of the patient. What's that mean? It means you go to the patient and you say, well, have you ever had a heart attack? Have you ever had kidney disease? Have you ever, are you on any medications? You get a history, you know, and coupled with that is, why are you here? What happened? And the patient will respond and tell you, okay? And so anything that's written down there came from her. How does that make it any more reliable? I'm suggesting it doesn't. It's simply what she told them. Is it surprising that medical people and law enforcement people immediately believe children? No, that's not unusual. Is it astounding that law enforcement and medical people, as a rule, tend to immediately believe a woman in a woman and man domestic situation? That's not hard to believe at all. Okay. I'm not suggesting it's appropriate or necessarily true, but I think just in this world of ours, it happens. It happens. And so the female gets to be the victim and the male goes to jail. There, that's how we're going to handle it. Because when she, cries or tells her story of, oh my goodness, it was terrible, and he did this and he did that and he did something else. Subliminally, I think people say, well, why would she say such a thing unless it was true? Write that out on a piece of paper. Why would she say such a thing unless it was true? You can switch just a couple of those words around and you can make it say, well, she said it, so it must be true. Which of course is not true of anybody. It's not true of anybody. We are not, the defense, as Judge told you, we're not required to produce any witnesses or offer any evidence. On the other hand, we did because our goal was to give you a rationale as to why Alyssa Clark's testimony isn't necessarily reliable and how it could aid you in terms of trying to explain some of the evidence that people have put forward and have now had admitted at this trial. The long story short, as you I hope now know, is that Mr. Clark, my client indicated that Alyssa Clark found out that he was sleeping with another woman, and ever since that time, she has just not been happy. And that the relationship between the two of them deteriorated, it seems like, over time, and that there was a time a few years ago when she apparently complained about Mr. Brooks, and it appeared as though law enforcement was going to take the case forward. He was, my memory of the evidence in this trial was that Mr. Brooks was arrested, charged, and subsequently the case was dismissed. I was not involved in that. I'll just tell you, so I don't have any personal information beyond that. That's just what I gathered from here. And, no fury like a woman scored is the thing that keeps popping into my head, but it is at least plausible. Okay? It's at least plausible that if she felt he should have been convicted, or if she felt that Mr. Brooks should have been, jailed or punished or something, and that didn't happen, well, by George, next time I'm going to make darn sure it happens next time. He didn't just push. He didn't just shove. Oh, he choked me. He choked me. Banged my head against the wall. Put a gun in my mouth. That'll get the police attention, won't it? You bet it will. And so the investigation was launched. We heard from our detectives. They interviewed Alyssa Clark and also Mr. Brooks, and we heard what was said to each of them. I'm particularly mindful of, and is the one about it's criminal sexual conduct in the first degree. Okay. Ms. Clark claims that she was not awake or alert or conscious when she believes a certain act occurred, but that subsequent she discovered a video, and she told us that that video was of her apparently in this unconscious state, and that Mr. Brooks penetrated her genital opening with his penis, and some other things that she told us. And the scientific world of the Michigan Department of State Police Crime Lab and the knowledge experience of the detective staff of the Lansing Police Department, what was the result? We didn't see any video like that. We didn't see it. Couldn't find it. Not there. Okay. Really? Does that cause you to at least pause as to whether her story is reliable? I should hope it would. And then the testimony of Mr. Brooks, my memory is that he said, oh yes, we did engage in sexual intercourse that same day. Later, you know, I got her awakened in the shower and you heard all that, she had vomited and so forth. But later that same day when she was awake and understanding what was going on, yeah, we did. I'm lastly, and I'm finishing up here, but I want to talk just briefly about this idea of reasonable doubt, with the caveat that the judge is going to read that to you tomorrow, and that's the law that you are to follow. But here's what I think about this idea of reasonable doubt. Okay, I want you to suppose for just a moment that your vote was guilty on a given count. Okay, just walk with me a minute. You voted guilty on a count, and then you're dismissed by the court. People gather their jackets or purses or belongings and did I leave anything back in the room? And you make your way out to the parking lot, and you're going to drive yourself home. Okay, and the first red traffic light that you come to, you're waiting. You're the first one in line. The light's red, and you're waiting for it to change to green. And you're tapping your finger on the top of the steering wheel, wondering, gosh, I hope I did the right thing. You did not do the right thing because you obviously have a doubt. And if that doubt is reasonable, then you mark the box that says not guilty. On the other hand, if the opposite is true, same car, same traffic light, your vote has voted not guilty, and you're wondering, gosh, I hope I did the right thing. Yes, you absolutely did. That's how this works. Okay. So, Mr. Brooks has demanded a trial and consented to putting his future in your hands. I have assured him that he is in good hands, and that at the conclusion of the judge's instructions tomorrow, you will deliberate in a manner that will be suggested to you in a business-like fashion and so forth. You'll hear all that tomorrow. And that you're not going to rush to any judgment. Talk about it. Talk with each other. Why do you feel that way? What did you see? What did you hear? What makes you think that? Okay. Because as far as the defense bar is concerned, it's just an ugly thing if the first thing folks talk about at the deliberation room is, well, I think he did. What do you think? Yeah, I think so too. What do you mean you think? Why do you think that? What evidence supports that? And just because you think it, does that mean that you have absolutely no doubt in your mind, no reasonable doubt remaining? It's a serious matter. I know you'll take it seriously. You'll take all the time that you need, and that you'll follow your oath and render a just verdict.